Supreme Court Grand 24 appeal exposes Justice Tsammani. Tinubu shocked as Peter Obi advice. Hello people, welcome back once again to this particular YouTube channel. I must tell you for the fact that Justice Tsammani, if we break down the rascal judgment that he gave during that 6th September judgment, a lot of you guys will be shocked. But I thank God that the grounds on 24, as a matter of fact, the Supreme Court has actually exposed this Justice Tsammani. Peter Obi's lawyer during the election petition tribunal, asked Justice Tsammani and told Justice Tsammani that Inec did not authenticate, they did not even validate the result, the Form EC8A that they used to announce Tinubu as the president. This is part of the petition that Peter Obi filed. They were asking the court, look at what happened, that Inec, even some of the results, even some of the results of the Form EC8As that we are torn or that we are under contention or that we are blocked, that there was no way that this Inec actually authenticated this particular results. And instead of Justice Tsammani to give a very fair judgment, instead of Justice Tsammani to look at the argument that these people brought, now look at what Justice Tsammani gave, look at the judgment they gave, and look at what Peter Obi, as a matter of fact, the Grand 24 that the Supreme Court will finally use to expose this Justice Tsammani, and it's going to be a very big embarrassment. Now let's dive back straight to the point. From the judgment that Justice Tsammani gave, you people should understand and follow with me from this. And I'm saying, you can see on the screen, the learned judge is quoting section 6 of the Electoral Act below. Said, we are during collection of results. There is a dispute regarding the collected result or the result of an election from any polling unit. If there is any dispute, if there is any problem, or if there are discrepancies from a polling unit result, that the collation officer or returning officer shall use the following to determine correctness of the disputed result. This is what Justice Tsammani is saying. Justice Tsammani, while giving their judgment, is trying to state how the collation officer will actually solve this dispute if there are discrepancies in the polling unit result or problem. Now look at what Justice Tsammani and his cohorts said. They said that look at the way to look at how to solve that problem if there is problem with a polling unit result. They said that the original of the disputed collected result for each polling unit where the election is disputed must be available. What the A is saying that if the result is being disputed, that the result actually the original of it that came from the polling unit must be available. Now they said B, the smart card reader or other technology device used for accreditation of voters in each polling unit where the election is disputed for the purpose of obtaining accreditation data directly from the smart card reader or technology device. Now what B is trying to say is that whatever technology is used to accredit voters or collect the number of votes in that particular polling unit or election area must actually be available. This is the number one material that is required is the original result that was gotten from the polling unit, which is under dispute. The second is that any technology, and in this B, the second technology we use here is BVAS. If you remember, it was BVAS that was actually used for the accreditation of votes. Now the C is that the data of accreditation recorded and transmitted directly from each polling unit where the election is disputed as prescribed under section 47(2) of this act. Now what C is saying that the data of accreditation recorded and transmitted, the data that was recorded in the BVAS machine is needed too, because we have to actually know the actual number of people that were accredited in the polling unit and compare it with the number that voted on the result that we have, which is the physical form EC8A. Now, the D part, they said that the last thing that was actually required is that the votes and results of the election recorded and transmitted directly from each polling unit where the election is disputed as prescribed under section 64 of this act. Now, the D is saying that they after considering the data from the BVAS, they will now have to consider the votes and the results and the election they were recorded and transmitted directly from the polling unit. Now, from the above, the learned judges are stating the procedures for verifying the authenticity or correctness of accreditation and the results scored by the political parties. You people should know that the step that we are giving was the step given by this Justice Tsammani and his cohorts, on how to settle disputes in order to authenticate the results and the accreditation and everything. Now, the issue is, how do you verify or compare the number of accreditation and results scored by the political party? This is where the very issue is. Now, how do you certify or how do you authenticate the number of people that we actually accredited and the results and the authentic result? Now, for you to know the number of people that we accredited, now to verify, you have to compare the number of accreditation. One needs the BVAS machine. according to section 64CB, and the number of accreditation recorded on the results transmitted directly, which is 64.6c, which are entirely different from the hard copy disputed results. So as in 64, so the information needed to resolve disputed accreditation must come from three distinct sources. Now, what this part is trying to say is, if you all could know that if you want to verify a result, if you want to verify the number of accredited voters, you need the data stored in the BVAS, the one that was written on the physical form EC8A, and the one that was uploaded onto the IREF. These are the three things that you need to authenticate the number of accredited voters. So if you check and if they all correlate, you have to correlate and equally state categorically that this is the number of accredited voters. Now, the fifth one is, how do you now verify? We've verified the accredited voters. Now, how do you now verify the results scored by political parties, if especially in a disputed result? Now, the one needs the result directly transmitted as in section 64.6d and the disputed hard copy. Therefore, one needs two distinct sources of results for this verification. What this thing means is that if Inec really wants to verify or authenticate the result from that disputed area, what they need to do is to compare the physical from EC8A, which was brought to their collection center, with the one that was uploaded onto the IRF portal. That means you need two sources, which is the physical from EC8A, which is the one that is being disputed, and the result that was uploaded to the IRF from the polling unit. Now, since according to the learned, look at what the judges said, and what I just listed for you is the right thing to be done. But look at what the judges said. The judges said there is no results electronically transmitted but physically transmitted, and they are saying that Inec hard copy in this boot would be used to verify itself, or they expressively saying will be no need of verification or comparison at all. Now, if you all remember in the judgment that these particular people gave, the rascal judgment that Justice Tsammani gave, he claimed that the RF portal was not important. But from what we've read before, you could see that for you to verify the result, you must compare the disputed result you have, which is the physical from EC8A, with the one that was uploaded onto the IRF. Now, if Justice Tsammani is saying that there is no need for the IRF portal, that means if we have a disputed result, of probably a result that is under contention, what are we going to use to verify that particular result? Are you still going to use the same result to verify the same result? Where are you going to compare and say, look at what I'm supposed to do, and look at where to authenticate this result from? Justice Tsammani, made this particular mistake, and this is what the Supreme Court, as a matter of fact, on ground 24, is going to annul. Because Justice Tsammani trying to make the IRF portal to become irrelevant means it goes a long way to tell you that he knows what he was doing. He was heavily paid to give that such rascal judgment. If a result is under contention, how then can we know the actual result? We can only know the actual result when we compare the one that they brought, because what happens is that before they bring it to the collation center, a lot of manipulations have happened. So the collation officer need to check the one that was brought to the collation center with the one that was uploaded to the IRF portal at that particular moment the election happened, and from that particular polling unit. So we are with the Supreme Court because a whole lot of things needs to be unraveled about the rascal judgment that was given by this Justice Tsammani. I would like you guys to drop your comments in the comment section. Tell me what you think about this recent exposition.